Yeah.
Rental today. We welcome you here. We have the wonderful Erin Christie and Jill Bowen here today. They are experts in this field, and they are going to let you know some news laws that are happening and some things that are going on in our community. And I'm going to change this microphone just for a second. Okay, so before we get started, first we have our people at the North office that are joining us. So I believe that they have already said that they can hear us and they can see our speakers. So it's nice that we can have a live streaming where people who live up in Manatee don't have to travel all the way down here, and they still get the same great content that we have. So before we get started, we have a lot to get to today. We do have a sponsor with us, and they're going to tell you a little bit about their company. You're good. You're right. If you're right here, they can see you.
Okay. Hello, Manatee folks. Just want to say hi. If I go out of camera, I apologize. It's just a little bit tight. But anyway, I am Julia Jones. I am the owner and founder of PuraClean. We are the paramedic of property damage. We have two different locations. One that serves more the north side of town, PuraClean in Bradenton, and one that serves south, which is the PuraClean of Lakewood Ranch and Fiesta Key. We pretty much cover from Pinellas down to Charlotte County. And one thing that makes us different than some of our competitors is we feel that we're one that you can trust in this field. Property damage field is it's one that has quite a lot of players, and we tend to play more by thinking customer focused than maybe the one. But in terms of when you would call us, you typically call us when something has gone horribly wrong. So in terms of property management or short-term rental, things that might be pertinent to this field would be water damage. And that could be the fire sprinklers go off, have somebody's toilet overflowed, or somebody left this faucet running. I can imagine it happening in short-term rental, possibly a lot. We do a lot of work in odor. And it can be pet odor, cigarette smoke, and we also deal with disinfecting, like maybe after an illness, if somebody's been in your space and it needs to be disinfected before they return home. That's something else that we work on. We're also trauma and crime scene certified, myself included. So if you do have an unexpected event, we do help with that. Tough deal to do. Sometimes we clean carpets, which is nearly as interesting as crime. But one thing we also just found out last week is in a franchise system of 350, we just made President's Circle. That puts us in the top 10% nationwide. So we're going in our fourth year of business and being woman-owned in this crazy male-dominant field. And thank you. I appreciate your applause. It means a lot. But in terms of like our phone number, just throwing it out there, but we've got all kinds of materials back there. 941-233-PURO, P-U-R-O. And I do hope you don't need us, but I definitely want you to think of us if something does occur. Now, when we're doing my job, we're going to have a drawing to collect business cards that maybe you could show her what we have. I thought this would be a nice welcoming gift for your short-term rental. So it has the anchor of the beach theme, and you can put a couple of bottles of wine on there. So we could be asking pretty business cards to collect, and we'll do that. And so thank you very much, Amy. Also in the back, I have a few extra. For preventive purposes, we have a water shutoff tags that you can give to your tenants. And if the water, something breaks, the pipe breaks, and when you turn the water off, where the hell is it? You can look for the red tag. And have PuraClean on the back too, just in case you need us, in case of an emergency. Well, thank you very much. Please think of PuraClean if you need us. And I'm Julia Jones, and we will be staying for the duration. So if you have any questions, feel free to approach us.
Thank you. And then, yes, they'll have their drawing at the end of the session, so, during break or during your restroom or at the end of the classroom, put your name in the, in for the drawing. So we have a lot to get to with, Christina and, Jill and Erin, so we're going to get started. Thank you for being here.
All right, we're excited to be here. I like that, you know, there was a female sponsor and now you've got a panel full of female lawyers and insurance professionals taking over the world. And we work really well together and we're organized. So we're here to talk about short-term rentals. This class is going to kind of come at this a couple different ways. One, we're going to talk about it from the contract perspective. You know, if you're helping a buyer, if you're helping a seller, obviously we're at the Realtor Association. We want to make sure that we're covering those contract things. But we're also going to talk about the regulations in the different municipalities and unincorporated Sarasota and Manatee County that that are at play. So if you yourself are investing and want to understand what you can and can't do, or if you're fielding these questions from buyers or sellers, what you can and can't do. And then Christina's going to talk about insurance. I think, you know, she and I kind of talk about this a lot. And it's like, it's not the rates that are the hard thing to deal with right now. It's actually insurance. And so having somebody like Christina who knows the ins and the outs of and the different things that we need, not just in, you know, purchasing a home to live in forever, but these short-term rentals and how that differs is so awesome. So we'll hear from her at the end. Anything you want to add about an overview, Jill? Or no, that's it. Yeah. Okay. Awesome. Jill and I are both real estate attorneys. We handle closings, among a lot of other things, but for today, we're just gonna talk about closings. All right. And I think that one overarching theme that I hope you all take from today is that, like, don't guess, don't think you know it. This is a hot button topic, right? These short-term rentals, the vacation rentals, all around the country, but especially in our backyard. And so just because something was true a year ago and you remember it and you just did it, double check, check in with a lawyer, check the ordinances, reread the contract. I am in this contract all day, every day, you know, 10 closings a week at least. And still, I have to reread the contract sometimes. Be like, what does that say again? Or how do I make sure that we're protected? Or what are they actually entitled to? And so I know we're in it a lot, but I just hope that you take from this, especially on these short-term rental issues, don't guess. Read it, check in with a lawyer, check in with your broker, whatever it is that you need to do. Okay, so you get to hear more from me first on contract. So we're going to go through kind of the basics of the contracts and things not to forget. And especially if you haven't been through a contract class recently or haven't kept up with kind of the changes in the last 2 or 3 years of what's going on in the contract, there are some changes in here specifically as they relate to short-term and vacation rentals. So I think the biggest thing that I see missed when a contract comes across my desk is that when a property is subject to, I mean, sometimes even just an annual lease, but definitely short-term leases or vacation rentals, is that the contract comes across and the box isn't checked. So 6B covers occupancy and possession. And it's really important that if your property as a seller is subject to these leases or these future tenancies, it doesn't have to be a, you know, literal lease signed and notarized or what, you know, however you want to document that. It can just be a Vrbo or an Airbnb reservation in the future. It could be an email between you and your friend that says, hey, in April, you can use this. And now you're about to close on the property in March. So just make sure that if you are subject, if the property is subject to these short-term vacation rentals or seasonal rentals or a lease at large, that the box gets checked because it's really going to control a lot of what needs to happen next. Bigger issue if you represent a seller and you don't check that box and the lease or the short-term rentals are never shared with the buyer and we get to closing. Again, this happens frequently. Oh, I forgot this is actually subject to short-term leases. Like, here's the list. The buyer technically has the right to cancel. Your whole deal could blow up because you didn't disclose, and by you, I mean the seller, but we're helping them because we didn't disclose that the property was subject to these future tenancies or leases. So we get our act together, we check the box. What do we need to do? The leases or the, dates of occupation, whatever that's going to be, needs to be provided to the buyer. And then the buyer has 5 days to review those and the terms of them and terminate if they don't like the terms. It's a little bit like the as is an inspection, right? They could just not like that they're leasing on a Sunday. It can be it could be anything like that, but they've got 5 days to review it. If you don't get the leases to them and you forget and it's the week before closing and somebody's like, oh, hey, there were leases here. Did we look at those? And then the seller gets the lease over to the buyer, they still get 5 days or until closing. So again, anytime that you delay getting those leases, those occupancies to a buyer, kind of like the condo documents, which we'll talk about in a minute, there is a right for the buyer to look at it, review it, see if they like the terms or not, and terminate the contract if they don't. So in the interest of keeping the deals together, you make sure you're reviewing this section and following it and getting any occupancies over to the buyer. Jill, anything to add? No?
Well, I guess the short-term rental, if it is a short-term rental, you still want to check this box, even if
Correct.
it's not that like long-term lease, and then you would provide the, like you said, the list of people and all of maybe the times that they're going to be renting and things like that. 'Cause
Right.
with Airbnb, you're not going to have like a traditional lease.
It's okay if it's not a lease agreement. It can literally be a printout of the dates of occupancy that are already booked, for example. So, frequently we see that with the Airbnb or Vrbo. It's, the agreement's not, sometimes there's an agreement that goes with each listing. Sometimes it's literally just kind of the terms of Airbnb and here are the dates. So it just kind of depends how organized the seller is and what documents they have up on those vacation rental sites for execution. Are we taking questions now or? Okay, we'll take questions, sure.
As a manager, my agent several times ran into a situation where a seller had just had a verbal agreement with a renter and nothing had been kept up to date print-wise. How do you deal with that?
The question is, what if it's just a verbal agreement and not an actual written agreement? So those still should be disclosed. Very hard to prove what it is, but if somebody, for example, came and stayed in your place every March and you just knew it, so now you don't have a written agreement, but verbally you've said, sure, every March from now until eternity, you can come and stay in my condo. That is a future tenancy or a future occupancy that should be disclosed. And while, like I said, it's harder to prove, you're still gonna fight about it if somebody is very upset because they wanted to use it in March. So yes, verbal should still be disclosed. I think I have a next page that,
We
okay.
have one more question.
Yep, another question.
If you get through this process, if you close, it wasn't disclosed, the future owner is still subject to those leases, correct?
Correct. So the question is, if you get all the way through this process and you close and it never got disclosed about these agreements, some of them, I just want to make sure I get this right because it can differ, unless you know off the top of your head. So if it's a material item that affects the value of the property, for example, that could be a misrepresentation to not disclose it. If you've disclosed that there's seasonal rentals and the buyer didn't, and you never provided the leases, and the buyer closes without seeing the leases, then the buyers are stopped from coming back. So the facts kind of matter. If the seller hid that these were subject to future occupancies or tenancies, that's a different issue. That's kind of a misrepresentation. Oh, we just hid it, we didn't tell you about it. If the seller tells you or checks the box, especially, hey, there are seasonal rentals out there. This is, been on Vrbo and we've got bookings for the next 6 months, and the buyer and the seller never sends it and the buyer never asks for it, now you can close without an issue. So the facts matter a little bit.
Yes, like.
Or a lot.
About those leases or short-term agreements, verbal or written, prevail and have to be honored by that future buyer, regardless of the fact that the seller did not disclose, or didn't disclose the right way, or disclosed that no one ever talked about it. I mean, all of those scenarios, leases take precedence over you can't just cancel those leases for short-term agreements, like, correct?
Right, so the question is, okay, so what happens if the buyer closes and then there are these tenancies out there? Do they have to honor the leases or tenancies that are there? The answer is yes. And if they, and so then to my point, yes, the tenancies are out there. If you wanted to cancel the agreement, you're really stepping into the shoes of the seller. And the buyer would really be looking to the seller for recourse at that point.
Yeah, because tenants have a lot of rights in Florida, right? Those leases are, you know, especially if you have a written lease, that's going to prevail, right? They're not gonna kick out the tenant in that case. However, you know, the buyer would probably have a claim for damages against the seller if it was intentionally left out. So that, I think that's what you were saying is like, yes, the tenants have a lot of rights, but there's still probably a claim if that was hidden. Now, I have actually had this happen with a short-term rental where someone closed. The seller never shut down their Airbnb account. And I don't know, they said that it was an accident. I don't know if that's true or not. And the buyer was remodeling the home. It was out on one of the Anna Maria, I think. And a few months after closing, someone showed up knocking on the door. Hi, I'm renting this place with my family for a week. And no one had any idea. And the house was completely gutted because they were in the middle of a remodel. I think in that case, they ended up getting they had some kind of Airbnb insurance, and the seller ended up paying, you know, they reached out to the seller pretended like they had no idea, and they ended up paying the family to go stay somewhere else, basically. But it was, you know, that was a big problem, right? Because there they were showing up at the door to rent the place, and no one had any idea. So, that's kind of like worst case scenario. Obviously, the seller did pay in that case, which was nice, but, you know, you're still having to chase someone down to fix that issue.
And we're going to get into these tips like towards the end of this part of it. But, you know, one of those things that you want to think about as you're drafting the contract is, do you want, if you're representing the buyer, do you want the seller to shut down their Vrbo, Airbnb account, anything that markets the property for lease or for occupancy, and then provide proof of that?
So why wouldn't they go automatically over the public records? Because that is gonna be transferable and the title is gonna be transferred to the owners. So why that cannot be made automatically on that property, even though being on a short term on the zoning, but yet again, not necessarily to be linked to the same account.
I'm not sure I understand the question.
So yet again, you said that the seller already had accounts with Airbnb,
Mhm.
but now that transfer of the title is to a new owner.
Right.
The new owner is not connected to the previous accounts, so why don't, in the public records, not necessarily automatically cancel that, because the seller, once the property closed, it's no more owner of that property.
Yeah, so the question is ultimately, you know, why doesn't, if the deed's recorded and you enter into these agreements with the seller, and then the seller sells to buyer and deed gets recorded in the public records, you know, why doesn't that trigger the, you know, future leases to stop, the account to shut down, like, right? That's the question. No, I think if you solve that problem for Airbnb and Vrbo, you're a millionaire. Because the issue
Yeah,
is,
they don't do it.
is that Airbnb and Vrbo do not have, and we're gonna get into this. So I think after this question, we're gonna move forward because you guys are asking great questions that will, I think, be covered. Is that Airbnb and Vrbo don't transfer. They don't have a good way to transfer an account from a current owner to a subsequent owner. You cannot transfer the account. You cannot, you have to shut it down. And even if you wanted to take all those bookings as the buyer and be like, this is great, this thing's already leased, let's go for it. You've got to go and get those all back and rebooked with people if you want to stop the account and transfer it. There's a couple different ways to work around that that are less than ideal, but we'll talk about it.
Yeah.
Okay. Okay. With, so here's the difference between, another difference that gets covered in section 6 of the contract between leases and these short-term or vacation rentals. Leases, the seller will be required to get a tenant estoppel from the tenant. And a tenant estoppel just says, it's signed by the tenant and says, this is how much I pay in rent, this is how much I have in security deposit. There's, no enforcement issues that I have against the landlord and I'm current, right? It's the tenant agreeing with whatever the seller said as far as what's out there, as far as the deposit, whether rent's being paid and the amount. On these short-term vacation rentals or these short-term rentals or vacation rentals, the contract doesn't require it. So estoppel letters are not required on seasonal or short-term vacation rentals. So our practice tip to you is, the contract's negotiable. Yes, I understand, like every time we mark it up, it's like a slightly less sexy offer. But if your buyer wants to understand, well, what's on deposit? Like, what is the rent going to be? And there isn't a better lease agreement or something like that. You can, write these things and write these due diligence items into the contract itself. But the contract's not going to automatically cover you like it will on the longer leases. Anytime I teach a class, I always like to say, section 19 is your cheat sheet. Like, go to section 19 before you finish drawing up a contract or before you have your seller sign an offer and say, is there anything in this, in this rider section that we need to add here that might help us, or we should at least look at so that we're asking the right questions. For these short-term rentals, these are the three that I think are the most important: the condo rider, the homeowners association rider, and then the seasonal vacation rentals rider. On the seasonal and vacation rentals rider, so it's not required to have this, but I really think it does a good job covering what kind of questions you might have for a buyer's intended use of the property and what we're going to do with the property in this escrow period when we get, from contract to closing. What can the seller do? What does the buyer want done with it? And so it's great to, sit down with your customer and say, hey, let's think through this and what we want to happen. So the first section says the seller, and you need to check a box, may or may not, after we get under contract, right, after the effective date, enter into new renewal, seasonal, or vacation rentals at market rate and terms for occupancy of the property by third parties after this closing. Well, a buyer may want a seller to keep going. Like, yeah, let's go. I want to fill it up. I'm not going to use it. I'm buying this as an investment property. Let's let the seller do it. Similarly, the seller may want to keep getting these reservations, because what if the closing doesn't happen? What if the buyer defaults? What if you have a 20-day inspection period and then the buyer cancels? So, it could go either way. The buyer might want to move into this house or condo, this property, and they might say, hey, stop taking them. We want to move in after that last one. And so you just need to figure out what the intended use of both, of whatever customer you're working with, the buyer or the seller. What's your intended use and how do we want this to work? And then check the box. Can they do it only with the buyer's approval of the rental terms in writing, or can the seller just keep taking them without the buyer's approval? Again, same idea. What matters? Is there anything that the buyer wants approval of? Because you can write something different. You can put this in additional terms or an addendum that says, but not less than $500 a night. Kind of whatever it is that your buyer is looking for or your seller is looking for, make sure they understand, because the contract's going to control once we've signed it. Any comments on that? All right. Okay, the other rider, the condominium rider. So in case you don't know, I feel like this is like a big picture item we need to cover. Chapter 718 controls condominiums and regulates what happens and what you need to disclose prior to a sale. And it is more aggressive than Chapter 720, which is a homeowners association. They are different. Condos are different than homeowners associations. Both can exist in one property. Think of like Prestantia, right? There's one big master homeowners association, and then these little tiny like neighborhoods, and some of those neighborhoods are condos. So you can have a condo association and a homeowners association. So I think a lot of us all know that, but it's always good to cover. With a condominium association, there are certain things that a seller has to provide to a buyer. It's spelled out in the contract. declaration, bylaws, articles of incorporation, most recent year-end financial information, which is not the budget. Keep that in mind. The most recent year-end financial information is not the budget. There's no requirement that a seller provide the budget. And if the seller provides the budget and doesn't provide the year-end financial information, they've not met the disclosures. And the frequently asked questions and answers document. So those need to be provided. And then a buyer has 3 days from the date they're provided to review them and cancel for any reason. So when you are representing a buyer who may want to be using a condo as a short-term rent, well, one, to lease it all, but definitely for short-term rental or vacation rental, the document that you're most concerned about reading through and having them read through is the declaration. The declaration controls the whole community, what you can and can't do, the use restrictions that you have. And I guarantee you it covers leasing in some regard, whether those leases need to be approved, how long you can lease for, how often you can lease for. The good thing to know is that Chapter 718 says an amendment to the declaration that prohibits a unit owner from renting their units or altering the duration of a rental term or specifying the number of times that a unit owner is entitled to rent their units. You can only amend the declaration in that way in association if the unit owner themselves actually consents to it. So if your person, your customer, bought the unit and there were no rental restrictions at all, right? Built in the 70s, free for all, do whatever you want, no rental restrictions. And then, you know, down the line, they said, gosh, it's really getting out of hand. We don't want to live in this seasonal community. We're going to amend the declaration so that you can only rent your units for a minimum of 6 months a year. Well, the law now says that unless you, so me personally, let's say it's my unit, unless I sign on to that amendment, that can't be changed. I get to rent my unit however I wanted to, and you can't force me to abide by that 6-month rental. But if you amend the declaration and then I sell my unit and that amendment's recorded in the public records, the buyer is subject to that restriction. So they can't change it on you if you own it. Whatever you buy it for, unless you sign off on it, you get to keep it. But when it transfers hands, the most recent amendment, if it changes, you know, the rental restrictions, controls for that buyer. Really important to understand because these things can change, they have changed, and you want to make sure that your buyer knows that just because the seller was able to rent it out every month or once, you know, weekly, doesn't mean necessarily that a buyer is going to be able to. And you need to review the amendment or you need to review the declaration for whatever party you are working with. We have questions. Go ahead.
So you're saying that the rules that applied when that person acquired the unit technically prevail for the life of that ownership, and they can't be changed without them agreeing?
For rental purposes only. When you take title to a condominium unit, those rental restrictions cannot be changed on you unless you consent to them. Correct.
Even for future leases, or do you mean if you're?
Even for future leases. The whole point is you bought understanding that you're going to be able to use your property in this way and they cannot change it on you. But if you sign off on the amendment, and trust me, there's a whole, like there's a consent and it's signed and it's notarized, like you will definitely know if you sign this amendment. And it gets recorded in the public records and you're gonna, you know, if somebody asks me, oh, can I lease this? I'm like, well, let me look. Did you sign this amendment that said that you can or can't? Correct. Okay, I'm gonna go this way so I don't forget.
A lot, as you know. So how is that handled in the association? Like, they have to send something to the homeowner and they have to sign off if they agree?
The question is, how does that actually happen for amending a declaration with a condominium? funny, not the area of law we practice in. My husband is right now a board certified attorney teaching a class on this to Michael Saunders, realtors. So there is an amendment process. It really matters, like, one, what chapter 718 says, but also what your declaration says. Notices absolutely have to go out before you amend a declaration. There is a quorum, there's a voting threshold required, and it can differ by community, but you would get a notice in the mail for, you know, any meeting coming up to contemplate that, and you would, I think you get a draft of it, say it like went off and you somehow didn't notice, you would still be getting updates of notices of drafts.
And don't have, do they think something you have to sign that you agree?
And so the question is, would the condominium association send you something that you had to sign? They will send you something that you have to sign if it's an amendment that requires your consent. Not all amendments are going to require your consent, but for this rental situation, correct. They would send you something that you had to sign. We'll go back the,
To change your ownership of your name to a trust, does that make it then suddenly a transfer?
I mean, we're getting into, not gonna go do some legal research.
Yeah, I
equitable title
don't know the
versus
answer,
legal
but
title.
probably I would say that's a transfer. And so I don't, yeah, but I'm not
It really
sure.
depends. Sometimes the declaration will also say, you know, a member of the association means, or like a unit owner means, and then they define it. Because this question will come up a lot with like an LLC. Well, who owns it, or who's entitled to use the property, or who's entitled to sign off on it? I mean, I would say that you're really looking to the declaration to control what is a transfer. In some condominium associations, for example, we know that condos often have to approve when you're going to sell or transfer property. Some declarations will say, but not if it's through probate, or not if you're just transferring to an LLC or a trust that you own 100, you know, you're the beneficial interest or owner of. And some don't, and they're silent on it. And then it's kind of a guessing game of whether it counts as a transfer or not. Some specifically say, if you transfer it out of the name that is on record with us, it's a transfer. So I can't give you like this is always the answer, but that's what you're looking at. You're looking at the declaration. We're gonna get to HOAs next. Okay, yes.
You mentioned just to basically, if you're grandfathered in, then the law doesn't apply to you until you sell. Basically, your rights are grandfathered in this case until you sell it to someone else, and then that new buyer is held to the new rules.
Okay, right. So I am going to correct you just a little bit for the purposes of nuance. Because you said the law won't, so if you're grandfathered in under these like short-term rental restrictions or whatever, that the law can't change on you. The governing documents of the association can't change on you. And that is different because the law can absolutely change on you. And it's up to the law to say whether you're grandfathered in or not. So like an ordinance, a state statute, that's not what we're talking about here. We are talking about the declaration, the overarching contract essentially that you take title of that condo subject to. That's what cannot change for rental purposes without you consenting to it.
And then the other thing, just a couple of topics, it's on the same topic, but you said that the obviously when you're negotiating with the seller, when the buyer is negotiating with the seller, you want to make sure that all of the terms about the short-term rentals are negotiated. So say you, as the buyer, say, I don't want any short-term rentals going forward by doing the DD rider, but you also said that tenants in Florida have a lot of rights. So basically, if you've negotiated that and you said, I'm going to live in the property, I don't want any more of these rentals, even though they have been secured after closing, can you then just say, I don't want any more rentals after this, it's going to be my private home? And does that, in terms of,
Yeah, let me clarify a little. So the question was about any new rentals that would be booked by the seller under this rider. So this is this is new rentals that need to be booked in the future, not rentals that already exist before you go under contract. So if you have some short-term renter that's already, booked, and then you go under contract, you're still gonna be bound by those rentals that were entered into before you go under contract. This is just talking about that period, entering into new rentals in that period between the effective date and the closing date. So can seller continue to take new bookings during that period?
But anything booked by that time, you have to honor, even if
Yeah.
you want to be living in it exclusively and not going to be a rental.
And that's why you want the seller to disclose everything, right? So you know who's coming to knock on the door, right?
But that's not entirely true, because a lot of those agreements are canceled.
Yeah, I should say,
It's not-
yeah, and we're gonna talk about,
Lease that-
yeah, I think we're gonna get into that Airbnb issue, but yes, a lot of those can be canceled, and if you agree to that ahead of time and say, hey, seller, I want you to go ahead and try to cancel all of these bookings, and the seller says, okay, and they're able to do that, that's fine as well, but they would have to go through the process of actually canceling.
Yep. All right. Okay, homeowners associations, different animal. And I don't know why, honestly. 718, the condo statute, you're far more regulated, probably because you're sharing walls and you're literally just living in a box in the sky. So, chapter 718 and condominium associations are more heavily regulated than homeowners associations. So again, going back to our big picture items under the law of how HOAs work. The disclosure is different in HOAs, right? In condos, we talked about the laundry list of documents you have to provide. And if you miss one, then you haven't accurately disclosed, and you get to kind of start your 3-day period whenever you get that final document. In homeowners associations, and this is why it's so important to attach these riders. I cannot tell you how many contracts come across my desk. The property is subject to an HOA and the HOA rider isn't on there. If the property is subject to a mandatory homeowners association, right? We're paying assessments, there's a declaration recorded, then if the homeowners association rider is included with the contract and everybody signs it, great. You don't have to provide the declaration. You don't have to provide the budget or the financials or whatever. It's just, this is the disclosure. The HOA rider has all of the statutorily required disclosures in it. You are covered if you attach the homeowners association rider. If you forget, everybody signs the contract and you're like, oh shoot, here's the HOA rider. The buyer now has 3 days to review the disclosure and cancel. So a little bit different than the condominium rider, HOA rider. As long as it's attached from the beginning, we're good to go. If it's not, then a 3-day period will kick in. So it's going to take a little bit longer to go through. I always have to reread it. 720 is a little bit different because in HOAs, any governing document, the declaration or amendment, and this is after July 1st, 2021, you're just going to have to go and check the date, that prohibits or regulates rentals or rental agreements applies only to a parcel owner who acquires title to the parcel after the effective date of the governing document or amendment. So that's like the condo association, right? We're like, okay, cool. We know that rule. We got it. Except an HOA can amend its governing documents to regulate rentals for a term of less than 6 months and can prohibit a rental of a parcel for more than 3 times in a calendar year, and those apply to everyone. So if you took title to property and there were no rental restrictions, you could rent your house, you could do whatever you wanted, okay. If the association amends the documents to say you cannot rent your unit at all for a term of a year, that doesn't apply to you unless you sign off. But if they merely amend the documents to say you can't rent for less than 6 months and you're limited to renting for to no more than 3 times a year, and you didn't agree to it, doesn't matter. It applies to you. Because the whole point, right, you think about the public policy of this is that people bought into the single family neighborhood, this planned community, and to live near other families or people like them or whatever it is, for whatever reason they bought in. And what more so in HOAs, I don't know, because that is what the legislature got passed. They're trying to limit these vacation rentals in single family housing and HOAs. So it's different than condos. That's annoying. Also, if the homeowners association is less than 15 parcels, this whole thing doesn't apply. So if you, I mean, we're just throwing spaghetti at the wall sometimes. Anything to add there? Okay. Okay. So, oh, we have a question. Yeah.
So just so I'm clear, HOA rules kind of, trump the condo?
No. So the question is, do HOA rules trump the condo rules? They have to be read in concert. So if there isn't, so again, let's use Prestantia as our example. If you have a master association rule about how often you can rent your piece of property, and the condominium association has less restrictive rental terms, the master association is going to apply. If the condo association has more restrictive rules for your condo, the condo is going to apply. It's really, you're going to the most restrictive covenant at that point. Because you can't violate either of them. That's, so it's. Okay, so other just contract considerations, see it all the time in these in these investment properties, let's say. And in the personal property section or in the additional terms, they just write turnkey furnished. We know what you mean, but it doesn't actually mean anything, right? Really, I'm not kidding. I have seen a closing nearly fall apart on $1 million property over silverware. Like, I was getting ready to go down to Bed Bath & Beyond and spend $250 on silverware because it just said turnkey furnished. Or maybe in that one, it might have said the photos in the listing agreement. Okay, well, I don't see pictures or plates or silverware anywhere in the listing or not the listing agreement, in the listing. I know it's annoying, but an inventory is really helpful, important. If your buyer or seller doesn't want to do an inventory, make sure, okay, are you good with something not being there or something being there? Because unless it's in the contract, it's not going to happen. It doesn't have to happen. And so when people don't want to go through the task of making an itemized list, I get in writing. I say, okay, you're okay if the dining room table's gone when you show up. Well, no, we want the dining room table. All right, well, let's write it into the contract then under personal property, because turnkey furnished, it's just not defined anywhere. There's not even case law on it. There's nothing that's going to define it for you. Similar, if the buyer wants to use the same marketing photos, like they really loved the Verbo photos or whatever they're using to market the property for short-term rentals or for lease, they can't just use them. As I stole photos off of the internet to make this slide. You really, somebody owns the rights to those and you need to find out who it is. So if the buyer really wants those, it's a great question. Is it the owner of the property? Is it the photographer? Does the listing agent own it, right? They might have bought and paid for it and have the rights to it. So find out who owns them. The buyer can say, you'll assign the rights to use the photos over to me. Yeah.
I've seen one fall apart over linens. So,
yes, I'm telling you.
Same thing, multi-million-dollar property. They were upset about the sheets being taken. So it happens all the time.
It does. It's good. I'm glad I'm not the only one with a crazy story to tell about it. Some other contract considerations. So these are the things we were talking about with the Airbnb and Verbo accounts. They can't be transferred. You can't say, well, I'm selling the property, so I'm going to assign my account over to the buyer. Nope. I mean, I guess technically you can give them your login. I've seen people do that. That's one of those things I said, here's a way around it that I don't love and I wouldn't want you to do. But some people change their email and password. I don't think that's a great idea. And so one of the things that you want to consider is whether or not you want to require the seller to shut down their account, whether that be now for future bookings or on closing date, for example. You want them to, how do you want to deal with that? Keep in mind, if you shut down an account, all the bookings that were there get canceled and you have to rebook all of them if you are the buyer of the property. So something to keep in mind of like the logistics of that. How I typically see it done, and I'll let you talk about, if you were similar or not, is that if everybody wants to honor the bookings after closing, right? The buyer wants the money from those and the seller says, sure, let's, I'll keep the account open. We would prorate, and this is really, you want it in the contract to do this, although, I see it done plenty without being in the contract because we weren't involved at the front end. Prorate any mid-term rental. So, right, if you're closing and there's somebody in the property currently and half of it goes to the buyer and half of it goes to the seller, you would prorate that and then require the seller to credit to the buyer for future rentals, because that money is going to get paid into the seller's Airbnb or Vrbo account. Can't do anything about it. That's where the money's going to go. Require the seller to credit the buyer for any future rentals that come through that'll be paid to seller's account after closing. Then what we do is to make sure that that happens is actually escrow the expected rental income and only disperse once the seller sends to, if I'm acting as escrow agent, sends to me, to escrow agent, proof that that money was paid to the seller. Once we know the seller has the money and what amount they have, right? Because they could be canceled, there could be a security deposit could be withheld. We want to know what the seller actually got into their account. Then we release what's in escrow to the buyer. And the reason I have this, like, you should see me trying to do like escrow calculations. I'm like a real estate lawyer for a reason, but we always get there. We always get them right. And so it's not a real easy, it's real clunky. There's not a great way to handle these seasonal vacation rentals. We tend to do it. We tend to do it more so with this escrow agreement situation. How about you? What do you guys do?
Yeah, I would say we do that as well. Probably more often we do we're going to cancel all the bookings, shut down the account, make a new account, a few days before closing or even earlier if possible, and have the tenants rebook on the new account. I guess it kind of depends on how many of those bookings you have. And then sometimes what else we're seeing is if we do have a property management company involved, they can sometimes assist in that as well. Like maybe they're managing those bookings and they can kind of talk to us about the best way to work in their system so that it's easy to rebook them. Because sometimes, the property management company is managing the Airbnb account, or maybe they're doing all the bookings through their own site and it's pretty easy to transfer it. So we'll work with the property management company if we need to as well.
Yeah. Awesome. And I think some of that comes down to like how risk adverse is your buyer. If they really wanted those bookings, once they get canceled, there's no guarantee they're going to get rebooked.
Yeah.
So I think that kind of comes into play a lot too.
Small on the escrow, also tax consequences, if that seller actually get the tax because it has to be booked. But I also, there are a lot of booking channels that are now doing transfer or rentals are.
Good.
So really only talking about Vrbo, Airbnb, both of them have, well, they're both doing a beta. We started about a month ago on transfer. So probably in about 2 or 3 months, is going to be a liability where the whole, you can take one account, move it. I just said there.
That is
Right.
great news.
Yeah. For Manatee County, this just in. Somebody here said that, the Vrbo and Airbnb are running a beta test to actually be able to transfer accounts, which is music to our ears. We can only tell you what we've been experiencing up to now. So thanks for the tidbit. Oh,
Anything else?
do you have anything else?
I don't think so.
You can stop listening to me for a while. All right.
Okay. Hi, everyone. I'm gonna take over for a little bit and, Aaron will keep jumping in, and talk about some of the local requirements and restrictions. My name is Jill Bowen. I'm also a real estate attorney in Sarasota. I prepared this handout, about 6 months ago, I think, for a different RAISM class. So if you got the handout, it kind of looks like this. I think it's about 4 pages. If you need it, I'm sure there's more in the back. I'm going to be talking about that a little bit. I am 8.5 months pregnant with another girl to add to our panel. So if I sound out of breath, that's why. So I apologize. But I'm going to be starting to go through this. And so we'll talk about these restrictions. And then I'm also going to talk about ADUs. So first thing that you're going to see on this handout is the state of Florida. So what we're going to do is we're going to kind of start off big picture, and then we go into the municipalities and kind of get smaller. So the big picture is the state of Florida requirements. If you're going to have a short-term rental or vacation rental, which I'm just going to call a short-term rental, you have to register with the Florida Department of Business and Professional Regulation, also called DBPR. And you have to get a license to have a transient public lodging establishment. So that's kind of one of the first things that you're going to do. And the reason why I should back up and give you some big picture. If you're working with a client that is an investor and they just think, oh, I'm going to come down to Florida and I'm going to buy a property on Siesta or Anna Maria, and I'm going to rent it out and make a ton of money on my short-term rental. That might be true, and that's great. There are a lot of steps that goes into it. And so one of the reasons that I made this handout is so that you can properly advise your investor clients to say, like, hey, this is some of the stuff that you're going to have to do in order to actually use this as a short-term rental property. And you don't want them to be blindsided by some of these requirements when they come up. So first thing is registering with DBPR. The second place you have to register for the state of Florida is with the Florida Department of Revenue. Why do you have to register with the Florida Department of Revenue? Because they want sales tax, right? So if you are going to be renting a short-term rental, you are going to be paying a 7% sales tax to the state of Florida. So that's a really important thing to remember. As the owner, you need to make sure that you are remitting that sales tax properly to the state of Florida. A lot of property management companies help with that as well, but that is a requirement for the short-term rentals. So then the rest of the items kind of on this list are broken down by the different municipalities. So this is for Sarasota and Manatee County. We have Sarasota County overall, the Manatee County overall, and then some of the other kind of overlay districts or neighborhoods that you're going to see in those counties. So I'm not going to read the entire thing to you, but I am going to give you a way to understand it and read it. I want to start with Sarasota County unincorporated. So just generally, you're not in the city, right? We're in Sarasota County. You can have short-term rentals for a period of less than 30 days, short-term rentals for a period of less than 30 days are prohibited, except there's one zone of the Barrier Islands that's there are different rules, and I'm going to talk about that. So in general, short-term rentals less than 30 days in Sarasota County are prohibited. That's kind of the big picture. Now, if we get into city of Sarasota, oh, awesome. Yes, we have a map here, city of Sarasota. Then the restrictions are a lot more intense, right? The minimum rental period is 1 week. And if you actually read the code, it says 7 full days and 7 full nights. That's what it says in the code. The reason I make that distinction is because I called a lot of local government employees to prepare for this. I think they're so sick of seeing my phone number pop up to make sure that I had all the information right for you. I asked them, okay, what if I live in the city and I want to rent my property for 1 night, but I'm going to leave it vacant the rest of the week, right? Technically, that is not allowed under the city of Sarasota code, right? It seems like it should be allowed, right? Because we're still meeting I guess the spirit of that rule, but they say that it is technically not allowed. Now I do know that the city commissioners are aware of this issue because I've heard it be brought up in different city commission meetings, so that could change. But if you have a property in the city of Sarasota, you need to advertise it as 7 days and 7 nights. Don't advertise it as a 1 day or 2 day rental, right? Because then you're going to be in violation here. Now, if you advertise it as 7 days and someone reaches out to you privately and says, I want to rent it for 2 days, you might be able to get away with that. I'm not sure. But in general, you want that advertisement to say 7 full days, 7 full nights. So I also, like I said, I prepared this 6 months ago. I want you to put a star next to the next line, additional requirements. It says no additional registration requirements. As of February 5th, the city commission for the city of Sarasota has voted to implement the same restrictions that are required in the Coastal Islands Overlay District that have restrictions about registration and getting a certificate for your vacation rental to apply to the entire city of Sarasota. And that's going to go into effect in July of 2024. So I will update this, once that goes into effect, but I just want to put a star, there's a little asterisk there that this is going to change. That used to be that only requirement was that we had that 7 days, but now if you're in the city of Sarasota, you're also going to be required to have some registration requirements. And I'm going to talk about what those are as well. So that's the first thing I want to note. The second thing, okay, so The next area that we're going to get a little smaller here, is the Coastal Islands Overlay District. We have a map of it here. Basically, what we're talking about here is St. Armands, Bird Key, Lido, and some of Siesta. We have a nice little picture. Has anyone seen this poster before out on Lido or St. Armands, the Stop the Hotel Houses? Or maybe you did a few years ago.
Yeah.
So let's see, I moved here in 2019 and I was starting to see them around then. So what was happening is that people realized that there was a market for short-term rentals right in these areas, and they were renting out their properties to 20 groups of 20 and 25 people at a time. And in a regular single family house, you know, they were kind of converting them, putting bunk beds up, you know, adding as many rooms as they could to squeeze people in there. And the residents on Lido and St. Armands were very, very upset about this, right? Because it was basically a big party happening in their neighborhood every day. And so there was a big push to add some restrictions to these areas for short-term rentals. And they were successful. In 2021, the section 34.5 of the City of Sarasota ordinances was enacted. And essentially what it did was it put additional restrictions on what you had to do in order to use your property as a short-term rental. So big picture, the Florida statutes doesn't allow municipalities to say no short-term rentals at all whatsoever, right? But you can add restrictions to the different municipalities to make it more difficult. And there's some of these restrictions are going to add costs. They're going to add inconvenience to the owners. Some of them are just, safety measures. There's all different restrictions that are included. So if you look back at this handout, some of the restrictions that you're going to see are, one is maximum occupancy. So like I said, we were seeing 20, 25 people staying in a home. That wasn't really in compliance with, the city fire code maybe, or it didn't make sense with the number of rooms. So there is maximum occupancy requirements for these districts, and it's broken down depending on what the zoning is for that area. And there's kind of a formula to figure out what that is. The other thing that was probably one of the most cumbersome, in my opinion, is the registration process. So you have to actually register with the city that says you're going to be using the property as a short-term rental. And in order to, when you apply for that, you are going to have to provide all of this information that's kind of in these bullet points. So some of this is easy, right? You have proof of ownership, no big deal. That's like your deed. Maybe it's property information like your property ID number, no problem. But some of them are a little bit more cumbersome. So we have a sample of your lease agreement. So you need to show what your lease agreement is going to look like. You have to show copies of all your licenses from the state, interior and exterior sketches of the units. That can be pretty annoying if you don't have that already. Maybe you have to go talk to an architect or an engineer to actually get you a sketch of your unit so that you can provide it as part of this application. So there's a lot of things in here that are going to make it a little bit more expensive to have a vacation rental. There's fees, right? In order to apply for this certificate, there's going to be a fee associated with it. And then every time you have to renew it, there's going to be a fee associated with that as well. And finally, when you go to apply for this certificate, you have to go through a registry or an inspection process. So now you have to schedule with the city to have an inspector come out and make sure that you have all of this information, you've met all the boxes on your application. And you have to, if you have an out-of-state investor, it might be kind of frustrating. Who's going to meet that person for the inspection? Who's going to be your designated agent that's actually going to talk to that inspector and get everything approved? Finally, it's typically a pretty long requirement of what has to be posted in the unit. So I have a box for here as well. Some of the things that we see a lot are emergency numbers, locations of hospitals or police contact, things like that. The name and number of the designated responsible party, and that person has to be available to the tenants. So again, if you have an out-of-state investor, you might have to have a designated party that's local that can assist if something goes wrong. And so, coordinating that is probably going to be maybe through a management company or, someone that's going to help you be your responsible party. You also have to post the maximum occupancy, evacuation instructions. all kinds of things like that. So these are just some considerations when you're talking to an investor. It's not so easy as like, let me open my Airbnb account, right? So I like to keep that in mind. Now, all of these requirements that I just went through for this coastal island overlay district, like I said, in July, are going to be applying to everything in the city of Sarasota as well. Okay.
Once there might be quite a little bit of the properties that are not registered or certified. Is that the same thing, right? Certified or registered, right?
So
They
there's,
need to get the certification, they need to register in order to get certification.
yes.
But what is what is in there in violation? What is the county gonna do about that? What are if there's penalties, if there is some kind of other things that county or city or whoever it's gonna be entitled by the zoning can do about it?
Yeah, so the question was, what happens if you're in violation? So another department that I called a lot was the city code enforcement department to talk to them about this. So the first question I had was, what's the most common violation that you see? By far and away, the most common violation is renting your property for shorter than the 7-day period, right? That's the most common violation that you're gonna see that they get calls about. And they said it's always a neighbor, right? A neighbor calls and says, hey, there's people coming in and out of this. I have a new neighbor every day. So also I should note, those calls are not allowed to be anonymous anymore. So if the neighbor is going to complain, they have to give their name and phone number. And then that becomes public record, just so you know.
List of the Karens.
Yeah, exactly. So what happens next? The first thing that they do, say the violation is for renting your property for shorter than 7 days. They actually use a third-party service to scan the internet to look for you advertising your property for less than 7 days. If you are found to be advertising the property for rent for less than 7 days, then they're going to send a code enforcement officer to the property, hang a notice on your door, let you know that you're in violation. The first notice, you don't have, you were basically told to get under compliance within a certain amount of time, nothing happens. And as long as you get under compliance. If you get a second notice and you still don't do anything about it, you may end up with a hearing, right, in front of the code enforcement board, and that would be in front of a magistrate. They would have to, review the case, research it, make sure that you are in compliance now, or if not, there could be financial penalties, and they will also suspend your certificate for renting the property, so then you cannot continue to rent the property. And then every day that you're out of compliance is going to be an additional financial penalty. So, and those can eventually end up as liens on the property, right? So it is pretty serious if you have a code violation and you just ignore it and don't resolve it, it will eventually end up in some kind of lien on your property.
All this registration goes through a tax collector office in each of the counties?
So no, not necessarily. No, it doesn't. So there's going to be registration with the state that's going to go through the Department of Revenue. And then there's also going to be registration through the city of Sarasota. So it's not through the tax collectors. For example, this area like St. Armands or Lido, that registration is going through the city of Sarasota, not the county tax collector, because this is a city district that we're talking about.
And what if it's in the county, let's say, not necessarily it's only short term, but vacation. But vacation is 2-3 months. So that excludes those short terms. So is that gonna be again in the county, or it's still in the city, or?
So the question was about county versus city and applying for this kind of certificate. You do not have to have a certificate for short-term rental in the county. You just have to make sure you're complying with that 30-day requirement. And the county has their own code enforcement department that would have a similar enforcement process to what I just described with the city.
And remember at the beginning when we said, don't guess,
Yeah.
this is a prime
Yeah.
example. Don't guess, know where your,
That's why we're here.
yeah,
Yeah.
I know, know where your property is.
Yeah.
Understand where to look, make sure you're looking in the right code when you're trying to figure out, hey, what can I do with this property? Keep in mind that, Siesta Key, where is that? Siesta Key is actually, is it right here?
Oh,
Oh, it's
yeah.
there. The really north part, like North Soda and Flamingo, not much of it, but that is the city.
Mhm.
The rest is the county. Like you really need to pay attention to where you are. The property appraiser site for your property that you're asking about, right? Inquiring about is going to include what municipality that you're in. So whether you're in Sarasota County, Manatee County, City of Sarasota, that's the best place to look. I think like the easiest place to look, but just make sure that you're not guessing like, oh, she said we didn't have to register in Sarasota County. I must be in the county. You might not be. Okay.
Yeah.
Two questions. What are the registration fees?
So the reason I don't have them on here is because they update them almost every year. So they change a lot. I want to say for the DBPR, it starts at $230 a year. But then that can go up as well. And then, with the city, I want to say it's like $350 or something to start. Yes.
Registration is 500.
Oh, see. Okay, yeah. So see, they just went up. I thought they just went up as well. So.
It's $250 and then the renewal is $150 without a cost for inspection.
Yeah.
So
there-
don't guess.
Yeah, and then, like I said, they do change fairly often, so you want to be aware of that. Yeah.
Okay, so how are they monitoring? Right, so you said that the city,
Mhm.
it will, as of July,
Mhm.
will now have the properties will now have to register.
Mhm.
So how are they monitoring?
So typically what happens is you get a complaint and then they investigate. I mean, now I have heard stories of the city code enforcement officers using that third party system to kind of scrub the web for violations, properties that are being advertised improperly or being advertised and they don't have a corresponding certificate. But typically, when they are low on manpower, they're getting a complaint and then they're investigating it.
What department is that? It's gonna be doing.
The code enforcement, city code enforcement, and same thing with the county is going to be the code enforcement department. Yeah.
And because this is a newer hot button issue, just like the last several years, and I think that we might see these registration fees drastically increasing. We might see code enforcement getting more aggressive earlier on, because if you watch these city commission meetings or these county commission meetings, or, one of the big conversations is, great, we have this registration system and people are paying like $300, but then to actually monitor and do something about it, we're losing money to have these regulations in place. And so you really, these are some of the big conversations happening from a policy standpoint and a budget standpoint that I think we've got more changes to come down the pike, because it is proving to maybe cost more. And the question is it worth it to our community? And if you can't put the dollars there, it's really hard for a commission to justify kind of keeping this up. Oh, that's okay. We have a question back there.
VRBO or Airbnb right now, you can look at Bulkgate, for example. There's so many Airbnb projects in Bulkgate. So how is, the city using a third party source to scan data or the county using this, and you have so many properties that technically are supposed to be a 30-day minimum and they're renting them for 4 or 5 days.
Yeah, can't get them all.
Yeah. I mean, yeah.
I work with an association with vacation rental owners. There, even 2 months ago, you could get away with 2 or 3 days. We intentionally, even 2 weeks ago, moved some properties to like 5 days, and within 2 days, there's no way right now. I will tell you, I shouldn't say public. They don't do it on weekends. But during the week, there's no way to get around it. We have not. We've tried just for curiosity, if nothing else. And every time we change something within 2 days, we're notified. Again, that's only in the last 60 days. Previous to that, it was crazy.
Right. Our legal advice is going to be different than somebody's practical advice.
Does the rule apply to individual homeowners who are renting out like a room in their house? Or, they're not subject to the same kind of, investment property regulations for the county?
Yeah.
I don't know the answer about partitioning.
That it has to be short-term rental regulations, meaning a minimum of 30 days on an entire house. Is what I've heard, but if there's someone who owns the property and is renting out one room in their house, they're not regulated by the same regulation.
And so that's a great question and something to look into. I don't know the answer off the top of my head for like city of Sarasota, Sarasota County, but what you're going to be looking at when you're asking that question is the definition of short-term rental or vacation rental or whatever they're regulating. You've got to go to the code and say, how do they define that in our code? And if it's the rental of a whole, unit or parcel of property, then maybe a room doesn't apply. But if it says any rental on property at all, then it could, but you're going to the definitions at that point, and it is going to be different code to code. There's not, one unified code for all of our local jurisdictions and municipalities. So you've got to, look at that specifically for your property.
Yeah, go ahead.
Joe, could you repeat what you said for Siesta Key? You're saying that Siesta Key is not considered a barrier island, but the northern part is considered a 1 week because it's city of Sarasota, and the rest is Sarasota County, which is 30 days. Second question is, how, if a community on Siesta Key chooses to, just like it works the other way, where say the minimum is 30 days, but the HOA says it's a minimum 90. So the 90 applies because the HOA takes precedence. What if the community in the southern part of Siesta Key chooses to do 7-day rentals?
More-
Is that
More restrictive
More restrictive always
ordinance,
wins.
law,
Yeah.
more
restrictions is going to apply because you have to meet both. And then we haven't actually technically gotten into.
Yeah. Let me
So
talk
in the
about,
city
yeah.
of Sarasota, it's the Coastal Islands Overlay District.
Oh yeah, that's this.
That's this. Now in Sarasota County, it's Bear Islands, and I'll let you.
Yeah, so there's a tiny portion of Siesta Key right here, the northern portion, right at the bottom, that's in the coastal overlay district, and that's gonna be the 7-day requirement, because that's the city. Then if you go south of that, which is below this kind of red line, so South Siesta, then it's like a mess, basically. But the big picture is, there are certain zone districts in that area where there's certain uses that are grandfathered in, right? So we'll see, like, I actually just talked to someone about this today. You see a property that has zoned residential multifamily in the southern part of Sarasota, then they are allowed to have some short-term rentals as well. And it depends on like how they were grandfathered in those prior uses. But in general, South Sarasota for like or South Siesta Key is Sarasota County. And so then we're in that 30-day restriction. But yes, what Aaron said is correct, is that more restrictive is always going to win out. So the HOA can't say, I'm going to allow 90-day or I'm going to allow 7-day rentals if the county says you're only allowed to have 30. So the more restrictive one is going to win, right? So the HOA can't let you rent the property out more often if the county doesn't let you. Does that make sense?
it does, and yet there are so many properties in the
Yeah.
southern part of Siesta Key.
And I will say,
Are weekly rentals.
Well, because
because
so if it is, you're in the county, so let's start at the county. And so you have to have no less than 30 days, except if you're on a barrier island and you're zoned RMF, which is residential multifamily. And so you'll see a lot of 1 week rentals because they're in condos, a duplex that's zoned RMF. And so those aren't subject to the same restrictions as somebody in like the yellow, the RSF, think of like Treasure Cove and
Mhm.
Heigl, right? Those are single family. But then when you get down to the condos along the beach, and again, generalization, but pretty much true, those are zoned RMF, residential multifamily.
That's the day.
they can, they actually
maybe
don't
not.
have any,
No, yeah.
they have no restrictions on time on those for the RMF zone. Yeah.
That is gonna be in the property record. You wanna.
Yep, if you go to the property appraisers, go to the property appraiser's website and look at what it's zoned for that parcel. My other advice about that is to email the county planning department. If you are not sure, Sarasota County Planning Department does a very good job, and you can say, hi, here's my address. Can you please confirm what my zoning is? And can you please confirm the length of the stay that I'm allowed to rent it for? So.
So if I'm being like really, am I calling this for the city of Sarasota? Am I calling the code enforcement department to say, hi, I want to register my property?
There's an online system to register it, but yes, you're gonna,
Code.
yes, yeah.
That's also applies for Venice as a city, that registration.
I don't know. I don't know. You will have to call the city of Venice.
Yeah.
I'm not sure. It's not on my list. I need to add that to the list.
But don't worry, Manatee, we didn't forget about you.
Yeah. So I do want to talk about Manatee quickly. So this is, you can see there's lots of colors on this slide. There are a lot of different municipality breakdowns in the Manatee County. And so I do have City of Anna Maria, City of Bradenton Beach, City of Holmes Beach, and City of Bradenton on this chart. They're all like kind of in the same spirit, right? You need to register, you need to have an inspection, you need to have certain things posted on your unit, but they all do vary a little bit. So that's kind of why I have it broken down in here. But again, these things get updated all the time. So check the code, check in with the local planning department in those areas. I do want to give one more piece of info that I got from the code enforcement department, that the second most common violation that they get calls about in both the county and the city is noise. But the county code enforcement and the city code enforcement don't actually deal with noise complaints. They get referred to the police department. So just be aware of that. If someone is allowing parties in their property and they are being loud after quiet hours, they're going to get a call from the police department, more than likely. So
How are we doing on time?
yeah, I know
A lawyer without a lot.
we only have 15 minutes left, so I'm going to quickly talk about ADUs because then I want you to hear about insurance. So really quickly, ADUs, what are they? An ADU, or an accessory dwelling unit, is an ancillary or secondary living unit that has a separate kitchen, bath, and sleeping area within the same structure or the same lot. That's a definition from the Florida statutes. They're also sometimes called like granny suites or mother-in-law suites. That's what we're talking about here typically. So recently, in the past few years, ADUs have become more popular. Actually, Manatee County started the charge on this, allowed ADUs, and now Sarasota County and the city of Sarasota has kind of jumped on board as well, allowing you to have ADUs on your property. There's a couple of different requirements. One is that you have to live on the property, right? So you need to be, if you're going to use the back house as an ADU, you have to be living in the primary residence there. And then so say I live in my single family home and I want to build an ADU in the back. When I'm building and I'm applying for the permit, one of the things that they're going to require me to do is sign an affidavit saying that the unit is going to be rented at or below 120% of the area's median income, which, they'll tell you what that is, because obviously that is going to change and fluctuate. But essentially the point of this is to create affordable housing, right? This isn't necessarily so that you can make a lot of money off of the property in the back, right? This is so that your family can stay together, or your kid coming home from college can stay back there, or maybe you want to rent it to a cousin, or you can rent it to someone else, but it needs to be affordable. It needs to be below that threshold. So that's something that I wanted to tell you. I also called the Sarasota County property appraiser to talk to them about this, because there is always a question about ADUs and homestead, right? So obviously you have to live in the primary for you to use an ADU. So you're probably getting a homestead exemption on your property. So if you start renting the ADU in the back to someone else, what happens to your homestead exemption? So what the property appraiser told me is that they actually very recently have a system where when you apply for homestead, you are actually going to indicate that you are now using your property as mixed use, and the property in the back, or the parcel in the back, the structure in the back is going to be used as an ADU, and they're actually going to carve out the value of that structure, and you will not have the homestead protection on that structure. So obviously that's not maybe beneficial for the homeowner, because they're going to lose the homestead on that carve out, but it might still be worth it if it's, saving money for like a mother-in-law or a child or something like that. So they did recommend that when you apply for homestead, you're making sure to check that box, because if they catch you or find out, right, you could lose your homestead exemption on everything in the meantime.
And pay fines.
And pay fines, and you don't want to get involved with that, obviously. And so, you just want to keep that in mind, especially if you're buying a property with an ADU and that's what you plan to use it for, that you're going to need to let the property appraiser know in order to not get in trouble in the future. So again, this can be a secondary structure. It can be like an attic or a garage that's converted, but it does have to have a kitchen or a kitchenette. You can add on square footage and make that section your ADU, or you can have it as, fully separated from the main house, but it does have to match the structure and style of the main house. Okay, so you're not going to have like cute little cottage in the front and like modern box in the back, right? They're going to want you to match the structure so that it's consistent on the property. So registration is not required for an ADU, but like I said, you need to let the property appraiser know so that you don't get a violation for your homestead. Question?
So is this only for rental property, like, for example, you have a mother-in-law, in terms of the homestead,
Mhm.
say you've got your mother-in-law living in it, or you've got a child living in it, then if it's not a rental, if you're not getting income from it,
Mhm.
does the homestead carve out still happen?
No, and in that,
When it's a rental?
yeah, that's if you're gonna be getting income. Yeah, because you're still using it as your primary in that case. Or maybe it's even your primary and you're just using it as like your office or something like that, right? Which is totally fine. You're still using the whole space as your primary. Oh, sorry. The question was, what if you have an ADU, but you're not getting income from it? You know, maybe you have a child living there or you're using it for some other purpose. And the answer was, yes, you can still have homestead for the whole parcel in that case.
You said ADU as a short-term or an annual rent, correct, per se, as long as you abide by the restrictions of 30-day minimum.
Yes, and as long as you're renting it at or below that median area income, right? So you can't use it, you know, when you get into a short-term rental situation, you might end up quickly meeting that threshold and then it's no longer affordable housing. So so you wouldn't be able to do it in that case. You have to make sure that it's priced properly so that you're still at or below that threshold. And that question was, can you use the ADU as a short-term or a long-term rental? And the answer is yes, as long as you're below that threshold. Okay. Do you want to? That's all right. Okay. I gotta text my dad.
Thank you, ladies. Again, Christina Fredericks with Atlas Insurance, coming up on my 20th year with the agency. So insurance geek at hand here. So I'll try, and I think I could do a whole day on insurance topics, but we'll try and keep this as brief as possible. So a couple of points to bring up is hazard and flood insurance policy. So hazard insurance typically covers damages of natural disasters, fires, hurricanes, other perils, just like Piero Clean was mentioning, water damage is a big one as well. So typically keeping in mind that hazard insurance covers that. Flood insurance is rising water that comes into the home. So I think in this instance, when we're talking about short-term rentals and the transactional of selling and buying properties, something to keep in mind that flood insurance can be assumed so that seller can agree to transfer that flood policy to the buyer. Both parties have to agree to that. And that is with the FEMA, the National Flood Insurance Programs policy. There are private flood insurance policies now that are sold through an insurance carrier. Those are not transferable or not assumable. So just keeping in mind, flood insurance is something that can be transferred, and usually a good idea when we're talking about these coastal homes and on the barrier islands, a lot of those are grandfathered in and are grandfathered in at a lower rate. Also talking about short-term rentals, if that was a primary home and moving into a short-term rental, there could be a surcharge for it not being a primary residence. So that could be the only change, but they could still transfer that or assume that policy to have that policy be grandfathered in on some of those rates. So also keeping in mind, flood insurance is separate from hazard insurance. It is not, you do not have flood insurance in the hazard policy. There used to be endorsements that they would have flood insurance endorsed onto certain homeowners policies. That has really gone away. That was a bad idea, and they're taking that really off the table for endorsements. So it is separate. And even though you may call and say the kitchen is flooded, or your tenant may call and say the kitchen is flooded, that's from a pipe leak or a pipe break. It is separate from the flood insurance, which is rising water coming into the home. Insurance for short-term rentals, if someone is buying a short-term rental or short-term rental purposes, you have to have specialized insurance. So they need to take into consideration what that means. So the insurance carriers will ask the same, timeframes as we're mentioning, as the ladies are mentioning up here, is how long is this rental? Is this an annual rental? They'll require annual leases. They'll say, is it less than 30 days? If so, is it less than 7 days? So they have their own specific requirements as well. And those insurance policies are written with certain language that needs to follow those sorts of terms in a short-term rental as well. If not, there is a potential that there could be a situation or a claim that can be denied if it is not disclosed on that insurance policy as well. Also making sure that the insurance policy covers liabilities related to short-term activities, such as having guests over, being injured in maybe a pool or a situation that maybe there was a party and something happening. So making sure that liability is also included in that policy. Nuances in converting to the short-term rental. Again, that different type of policy and the different forms and defining such as those. Again, this can typically not be endorsed on. So if it's something that you are a primary residence and switching to a short-term rental, or it's an annual rental changing to a short-term rental, it's not something that can be endorsed on. It's generally a rewrite of an entire policy because it's to a different form of insurance. So keeping those languages different of the different forms. Differences between condo and single family. So going back to what the ladies mentioned with the statute, the 720 and the 718, there's certain statute requirements and those insurance policies follow that. So when we're talking about the walls inward with the 718 condo policy, your insurance policy has to follow that as well. And it can even get more sticky if there's a homeowners association running as a condo association or vice versa. So there has to be some communication. It can't just be, I need you to insure this home for me. It goes a little bit more in depth in regards to that as well. So again, different forms and how the policy will respond. Single family homes may be different, such as coverage, detached structures as well. We were talking about the ADUs and bringing that up as well. So just detached structures may have different coverage than the primary home, or it could be excluded specifically other structures. So we want to make sure if it's detached from the main home, that coverage is included as well. Insurance needs for the ADU, kind of mentioning the same, that the owner lives in the main home. Again, different form of insurance. Is the owner occupying the home while it's also being used as a rental, or is it only a rental with no unit owner being involved? Again, that's part of the form of the insurance following it as well. And then specific hazards, pools, golf carts, bicycles, all scary stuff in the insurance world to let tenants just have access to. So we need to keep that in mind. There's been some terrible claim stories I won't even get into today, but with golf cart uses, we see that a lot up in Anna Maria Island, where they have the home be available to the golf cart available to those tenants. And that can be a scary situation with people driving those things. So pools, bicycles as well, same thing, golf carts, any of those. Yes.
So is that just covered under kind of the general liability, or do you have to specifically state in your policy?
Correct. There could be specific exclusions that a tenant cannot use these items, a pool, a golf cart, a bicycle, whatever may be on the premises. We've had situations where keys of a boat were left, but not necessarily disclosed that they could use the boat, and then damage happened with bodily injury involved. So
Disclose everything that
should all be disclosed. Yep, absolutely. And then you want to make sure that you have the correct insurance in place. Don't assume that you have liability coverage on your rental home insurance policy, that it's going to extend to all of these things, such as pool, trampolines, all the fun things that all the kids were renting the homes for in the first place. I don't know if I repeated that question out loud, did I? That is really it for, yes, go ahead. It will depend on what the requirements are of the association in regards to a high rise and what they require, what the association does require. If you own the building outright or a single family outright, you won't be required by a lender to have insurance, of course, if it's in a high risk flood zone. But you will be required to have insurance if there's a lender involved that requires that insurance. So also don't think of it just as water coming in, you're on the 8th floor of the building. The foundation of a building can still be compromised by insurance or by flood as well, which then your insurance of flood can still respond even if you may be on the 8th floor. Good questions. I know I'm flying through this because we're at the very end and I could again do this all day. So any other questions, of course, I'll have my contact information. Yes, go ahead.
Manager, I've heard that we have to have additional, have the management company be named additional insured. Some insurance companies are fine with that and some are not.
Correct. They're mentioning about the property manager being listed as additional insured. So there is difference of different additional insured gives rights to the policy, where additional interest just gives you interest in the policy. So there are insurance carriers, depending on that language of that form, that says, if I do this as an additional insured, we're giving them rights to this policy and this coverage, where additional interest would only give them interest in the policy to make sure, is coverage in place? Is it in effect? And is it the correct limits that we want following that, whatever the guidelines of the property management have? Good questions. Yes, go ahead.
Oh, no.
Take questions from the, Christine, I was just gonna ask, how easy is it to transfer the NFIP flood coverage from the seller to the buyer?
Actually,
Is it,
yep.
okay?
For transferring flood, how easy is it? It's actually an easy task to do. It's a signed document of both seller and buyer. The only difference is if it's midterm of that policy, we need to determine, is there transfer of funds that the flood insurance does not return premium of unused premium back to that seller. So that would have to be an outside agreement between both parties. Either they decide it's fine, just take the policy and I'm giving that to you as, part of the transaction, or do they decide we're going to prorate this and you owe me as the buyer X number of dollars because I didn't use the entire year's premium.
That's the only, thing that a seller could raise, has to do with that part. There's nothing else that a seller could say, I don't want to transfer my flood policy.
There has been instances that sellers do not want to transfer the policy. I can't tell you that there was even a reason why to not do that, other than just being grumpy, but you can do it and it's very easy. Yes.
Is there, what are we looking for in insurance policy, a property management company for short-term rental, or we're checking to make sure it covers short-term rental? Is there a name, a clause?
Unfortunately, there's not a name or a clause. Generally, it's a dwelling fire policy. And there's different forms of those dwelling fire policies and how much coverage. The broader coverage is obviously best because it covers most of those instances. So just thinking of the different forms, but you really want to speak to the agent in specifics and say, show me where this is mentioning that the tenant is insured or I'm insured in this situation.
Okay, we want to open it up to questions that are of Bradenton office. Jamie, are there any questions there for Jill?
No,
or-
we are all set. Thank you so much.
Okay,
We've got one
for Michelle.
right
we
here.
have one last question.
There's certain insurance companies that are more friendly to SDRs.
Yes, yes, absolutely. Yeah, the insurance market in Florida in general has had a tough few years. And more and more are opening up, and definitely at first, even with properties listed in LLCs or trust names that were more difficult, they're really coming into realizing that's just the way of the future. And so they're becoming much easier on even short-term rentals of 3-night minimums. So yeah.
Okay, thank you very much. Thank you
Thank
to
you.
Erin, to Jill, to Christina. Thank you for sharing your expertise. Their information can be found on our website because they are business partners with us. They also have shared their contact information with you. So thank you very much for being here. If you have any further questions, feel free to reach out. We do have our prize winner for Puro Clean, so let's see who the lucky winner, is.
Is there anyone who didn't give me their card? Can I keep around? Okay, all righty, so here we go. Open the draw. Saren Balasieri. With, KW.
Congratulations. Thank you, everybody, for being here.
Thank you.
Oh, sorry to like the, like they.
No,
Appreciate you so much. Oh, my God, do I appreciate you. This